Apologize again. I promise I'll try to speed things up here again. So. Anybody technical issue? So we'll just go off notes instead of the PowerPoint. Before the break, we were talking about the controlled substances and the role that they were the levels that they were found in, the role that they may have applied or contributed to Mr. Floyd's death. And I was suggesting to you that it is, again, this death needs to be looked at. Mr. Floyd's death needs to be looked at, as Dr. Baker describes, a multifactorial process. This is the way the human body works. Heart beats, the lung breathes, the blood circulates, the brain thinks, the brain controls all of our movements, right? All of this. And to simply come in and say, this particular substance or these combinations of substances, when taken in combination with each other, when taken in combination with a person who has blockage in the heart, substantial, significant blockage in the heart, when we know that these drugs play a particular role in how the blood circulates, to just poo-poo it and say it has nothing to do with anything is just really a preposterous notion. Yet Dr. Baker, Dr. Fowler, and Dr. Thomas have all certified deaths at levels less than 11 nanograms per milliliter or 19 nanograms or combination, right? These deaths have been certified on that basis alone. And it didn't necessarily contain any of the other issues that were confronting Mr. Floyd on that day. Likewise, again, every other doctor that has testified has gone to great lengths to dismiss the role of Mr. Floyd's heart disease and hypertension in this case. Forensic pathologists define coronary artery disease resulting in death. Death can occur with 70 to 75% blockage. That is sufficient to cause a person's death. Every pathologist who testified in this case has indicated likewise that they have certified deaths with those types of blockage and attributed it to the coronary artery disease. Yet here again, this has played zero role. Dr. Rich testified Mr. Floyd had a healthy heart. Coronary heart disease, not relevant, according to the state. Hypertensive disease, not relevant. Drugs acting to further constrict an already diseased heart, not relevant. Adrenaline coursing through Mr. Floyd's body, not relevant. What does adrenaline do? It further constricts the arteries, right? Adrenaline from the paraganglioma wasn't there, didn't happen, played no role. They just want you to ignore significant medical issues that presented to Mr. Floyd. And the failure of the state's experts to acknowledge any possibility at all, that any of these other factors in any way contributed to Mr. Floyd's death defies medical science and it defies common sense and reason. Now, Dr. Chauvin ascribes the death of Mr. Floyd, essentially, as I understand again, to hypoxia, low oxygen, resulting in brain, going to the brain, low oxygen to the brain. Dr. Fowler also ascribes the death to hypoxic death, but that the heart was the muscle that did not get the oxygen, resulting in a sudden cardiac arrhythmia. The reasons that Dr. Fowler dismissed the notion of brain hypoxia are because, number one, hypoxia of the brain results in certain observable symptoms. The brain demands more oxygen, right? It takes 20% of our oxygen to function the brain, even though it's it's a smaller percentage of our body. It is the most sensitive to the loss of oxygen, and it reveals a progressive set of symptoms. Confusion, which was not exhibited, right? Because if you compare the testimony about whether Mr. Floyd was intoxicated, well, he didn't exhibit any confusion, right? Restlessness, not exhibited. Shortness of breath, it was complained of, but that is also a sensation that can be caused by a sudden cardiac arrhythmia. Visual changes, not complained of. Incoherent speaking, not complained of. When someone is experiencing hypoxia to the brain, as Dr. Tobin stated, you would see an increased ventilation or respiratory rate. But Dr. Tobin said it is a completely normal respiratory rate, 22 breaths per minute. The timeline in this case is consistent with a sudden cardiac arrhythmia. At 8:23 and 58 seconds, Mr. Floyd speaks. I really can't breathe. If you can speak, you have oxygen in your brain. At 8:24:09, he again verbalizes, please, I can't breathe, indicating at 8:24:09 that his brain has oxygen and there is no impairment to his airway. 39 seconds later, Mr. Floyd goes limp at 8:24 and 48. A person can hold their breath for 39 seconds, right? For 39 seconds, right? That does not result in hypoxia in 39 seconds. 27 seconds later, according to Dr. Tobin, Mr. Floyd takes his last breath. It's a total of 66 seconds, 1 minute and 6 seconds from the time that we know there's enough oxygen in his brain to speak. No occlusion to the airway at that point. 66 seconds from his last word to his last breath. This timeline is consistent with a sudden cardiac arrhythmia. It is not consistent with the longer process of brain hypoxia. Dr. Fowler's final analysis was that Mr. Floyd died from a cardiac arrhythmia due to atherosclerotic and hypertensive cardiovascular disease during restraint by police. Other significant factors: fentanyl intoxication, methamphetamine intoxication, possible CO, carbon monoxide exposure, and the paraganglioma. What role did Mr. carbon monoxide play in Mr. Floyd's death? We don't know. Nothing was ever tested as far as the vehicle is concerned. We don't know if the car was emitting carbon monoxide. We don't know. One thing we do know is that it was running. And how can we tell that it was running? Because in the video we watched earlier, when Thomas Lane pulls in that squad car at Cup Foods, he puts it in gear, he takes it out of gear, he puts it in park. He never touches the keys of that vehicle, and he gets out. The car was running. I have one last point to make, and I should be fairly quick with this. The superseding cause that was discussed. A superseding cause is a cause that comes after the defendant's acts, alters the natural sequence of events, and is the sole cause of a result that would not have otherwise occurred. Now, let's look at the medical timeline here. We know that EMS was called initially at code 2 at 8:20 and 11 seconds. We know that EMS was stepped up to code 3 at 8:21 and 35 seconds. We know that EMS responded to Cub Foods based on the videos at 8:27 and 27 seconds. We know that EMS called for fire at 20:38, 36. It takes approximately 3 minutes for EMS and the arresting officers to put Mr. Floyd into the ambulance, and the ambulance pulls away from Cup Foods at 8:30 and 17 seconds. Fire responds to Cup Foods at 8:32:59. That's 4 minutes and 15 seconds after they were called. That's pretty close in consideration to the 3-minute expectation of Miss Hansen. But the ambulance had driven several blocks away to 36 and Park, arriving sometime between 8:31 and 8:33. That's 1.5, and we know that because there are two exhibits, 62 and 63, that were introduced. 62 shows one paramedic and Officer Lane in the back. 63 shows two paramedics and Officer Lane in the back. So somewhere between 1.5 to 3 minutes to get to 36 and Park, where they began the resuscitative efforts. The first air is pumped into Mr. Floyd per Dr. Tobin at 20:35:06. That is 10 minutes after Mr. Floyd went unconscious per Dr. Tobin, but it is 7 minutes and 46 seconds after EMS responded to Cup Foods. We ultimately know that the ambulance left 36 and Park at 8:48 and 23 minutes. It arrived at HCMC at 8:53, shortly after 8:53. So it took about 5 minutes to get from 36 and Park to HCMC. What would have happened if EMS had started resuscitative efforts right away? What would have happened if, rather than driving to 36 and Park, they went to the hospital? They would have been there in that time. I am not suggesting to you that the ambulance paramedics did anything wrong. But it raises the prospect of that continued delay in resuscitation. What if EMS had administered Narcan? We heard that it would not have hurt him, and it could have helped him. I'm not blaming the paramedics. More importantly than this analysis is it shows that human beings make decisions in highly stressful situations that they believe to be right in the very moment it is occurring. There's lots of what ifs that could have happened. What could have happened? What should have happened? Lots of them in lots of regards. But we have to analyze this case from the perspective of a reasonable police officer at the precise moment with the totality of the circumstances when it comes to the use of force. We have to look at the cause of death to determine, did Mr. Floyd die exclusively of asphyxia, or were there other contributing factors that were not the natural result of Mr. Chauvin's acts? Right? Things that happened that were set in motion before Mr. Chauvin ever arrived. The drug ingestion, right? The bad heart, the diseased heart, the hypertension. All of these things existed before Mr. Chauvin arrived. The struggle, what role did the struggle play? We know, based on a prior incident, that Mr. Floyd's heart was beating at 219/160 in a situation where he was confronted by police and had ingested drugs. He didn't die that day. All of this, ladies and gentlemen of the jury, all of this when you take into consideration the presumption of innocence, and proof beyond a reasonable doubt, I would submit to you that it is nonsense to suggest that none of these other factors had any role. That is not reasonable. And when you, as members of the jury, conclude your analysis of the evidence, when you review the entirety of the evidence, when you review the law as written, and you conclude it all within a thorough, honest analysis, the state has failed to prove its case beyond a reasonable doubt. And therefore, Mr. Chauvin should be found not guilty of all counts. Thank you.
Members of the jury, there's an issue I need to discuss with the lawyers, so we're going to send you back to your room for probably about 5 minutes. All right. Immediately before the court was ready to resume, the state indicated it wanted to talk in chambers, but for a curative instruction, there's no need to go into chambers. What's your motion?
Your Honor, the state
Oh, you can be seated, but we need you near the microphone.
Thank you, Your Honor. Your Honor, the state requests a curative instruction as to the issue of intent. I believe that the counsel made a misstatement of law when he indicated and argued that the defendant had to intend to apply unlawful force, as in he had to intend that the force he was applying to be unlawful. That's not a correct statement of the law pursuant to Dorn at 887 Northwest 2nd, 826. The state need not show that the defendant meant to or knew that she would violate the law. But that is what Mr. Nelson argued before the jury. And so we're requesting the court give a curative instruction to the jury as follows: that it is not necessary for the state to prove that the defendant intended to act unlawfully, only that the defendant intentionally applied force to another, that this application of force was unlawful, and that this application of force resulted in bodily harm. I believe that is a correct statement of the law.
Which is contrary to what the court instructed in the first set of instructions.
Your Honor, I believe the court's instruction was that the intentional infliction of bodily harm requires the proof that the defendant intentionally applied unlawful force to another person without that person's consent, and that this act resulted in bodily harm. You did not instruct that the defendant need to intend that his force be unlawful, merely that he intended to apply the force, which was unlawful.
I'm going to deny the request for curative instructions. I will reread before the beginning of rebuttal statements of judge and attorneys, which starts at the bottom of page 2 and goes on to page 3, which specifically states that if an attorney's argument contains any statement of the law that differs from the law I give you, disregard the attorney's statement. I'll reread that, turn it over to Mr. Blackwell, who I assume will answer this exact question or this exact issue in his rebuttal.
We do ask the court's guidance on another issue, and that is when Mr. Nelson argued, quote, Mr. Chauvin thought that he was following his training. There was no testimony from Mr. Chauvin, and he didn't argue that they could infer that. He argued that they thought that. Placing that in context puts us in a difficult position in that we can't comment on his failure to testify, but that that statement is directly at odds with the evidence in the record.
Mr. Nelson, any response?
Read the quote, Steve. Excuse me.
So Mr. Chauvin thought he was following his training.
What was the context I said that in?
Well, it was when in your use of force discussion, you were talking about a reasonable officer following his training. You indicated that Mr. Chauvin thought he was following his training.
I don't recall saying it, Your Honor. I mean,
Even if you did, it was drowned out by a reasonable officer. I think it's a reasonable inference to draw from the evidence that exists. Even his statement to Mr. McMillan essentially was an indirect way of saying he was following his training. It's a reasonable inference for counsel to argue from the evidence. And to respond to that specifically by saying there's no evidence would in fact be commenting on his right to remain silent. So the bind the state is always in. So, but as far as the other issues, you can talk about requoting what the elements are on assault in the third degree, and also anything else that you think was a misstatement of law. I will read them, the statements of judges and attorneys, if you wish. And actually, before I do that, do you want me to read that? Reread that, or should I?
Yes, Your Honor.
Okay. I don't want to force it on you, but that would be is to remind them that any statement of the law that differs from mine should be disregarded.
And I would also ask that you reread the instruction on causation, because I believe that what Mr. Nelson argued was that the state is required to prove beyond a reasonable doubt that the other issues that he spoke about had no effect, right? Had no causal connection. And that is not the law.
I'm not going to single out that instruction and re-instruct on that. I'm just going to read them the general one, and that if it differs, and I'm sure Mr. Blackwell is going to point out in great detail how Mr. Nelson misstated that.
Yes, Your Honor.
All right, bring the jury back.
I would note that during the state's principal argument, in terms of contradicting the defense argument, the state made comments about essentially about the nonsense of the defense in this case, and it is improper.
I know what you're going to say. We'll hold that thought. All right, be seated. Mr. Blackwell, you may get the state's rebuttal. Members of the jury, before Mr. Blackwell begins, I'm going to reread one of the instructions. And that is specifically that attorneys are officers of the court, and it is their duty to make objections they think proper and to argue their client's cause. However, the arguments or other remarks of an attorney are not evidence. If the attorneys or I have made or should make any statement as to what the evidence is that differs from your recollection of the evidence, you should disregard that statement and rely solely on your own memory. If an attorney's argument contains any statement of the law that differs from the law I give you, disregard the attorney's statement. Mr. Blackwell.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. Last lawyer, I think, talking to you with closings will be me, and I won't be too long. I'm going to start talking to you about what I call the 46th witness. You actually have heard from 45 witnesses on the stand, but there is a 46th witness. And this witness was testifying to you before you got here to the courtroom. They testified over everybody else's testimony on the stand. It's the only witness that will be talking to you when you're back in deliberation. And that witness, ladies and gentlemen, is common sense. Common sense. We'll continue talking with you all the while, because while you've heard hours and hours and hours of discussions here in the closing, ultimately it really isn't that complicated in what it is you have to decide with respect to the excessive use of force and the issue of causation. In fact, it is so simple that a child could understand it. In fact, a child did understand it when the 9-year-old girl said, "Get off of him." That's how simple it was. Get off of him. Common sense. Why is it necessary to continue applying deadly restraint to a man who is defenseless, who is handcuffed, who is not resisting, who is not breathing, who doesn't have a pulse, and to go on and do that for another 3+ minutes before the ambulance shows up, and then to continue doing it? How is that a reasonable exercise in the use of force? You can believe your eyes, ladies and gentlemen. It was what you thought it was. It was what you saw. It was homicide. Now, Mr. Nelson spent quite a bit of time saying to you, perform an honest assessment. Look at all the evidence. Consider all of it. Reasonable officer. Reasonable officer is not magic words that you simply apply to Mr. Chauvin, and then he becomes a reasonable officer because you applied those words. Reasonable is as reasonable does. And here, what you saw wasn't reasonable, and you didn't get the whole truth. Notice how when you had the discussion about reasonable officer, Mr. Chauvin, the whole narrative cut off before we got to the point that Mr. Floyd was not moving, that he was not conscious, that he didn't have a pulse, and that Mr. Chauvin was still on top of him even when the EMTs showed up, and he still didn't get off of him. How is that what a reasonable officer does? And then if you look at the totality of the circumstances, which you heard so much about, what does that tell you exactly where he was coming from? If we're talking about reasonable officer. Now, you heard any number of other things that, in looking at the totality of circumstances and trying to do an honest assessment, you didn't get the whole story either. You got bits and pieces and parts. And I call them a story, ladies and gentlemen, because it's either completely not true or the facts have been altered in order to make a point to you, which also makes it a story. What you're going to reach when you all deliberate is a verdict. Verdict is a Latin word that means the truth. You're not going to reach a story when all is said and done. You're beginning at the truth. Why are we engaged in telling stories when we've heard evidence, facts from the stand? Why is that? But you just heard a number of them. I'll give you a few examples of the stories. You were just talked to about how safe the prone position is. And you've heard this in the trial. The prone position is safe. Here are the Canadian studies. After everything you've heard, you already know now that not a single one of those studies ever examined anybody who had a knee on the neck. You know that. You also know that about these so-called prone studies, none of them actually measured what was the oxygen reserve. That is, how is the oxygen actually being affected by putting somebody in the prone position and any amount of weight on them? They never even measured it. You know that too, although that wasn't brought up when you've been told about the studies to show that the prone position is safe. You heard again about excited delirium. There was not a single witness who sat in that chair and gave you testimony under oath who told you that they felt that Mr. George Floyd suffered from excited delirium. Not one. One of the criteria for excited delirium is the person's impervious to pain. They don't feel pain. They're not people saying my neck hurts, my knee hurts, everything hurts. They're not grimacing because their wrist hurts for excited delirium. That's a fact. If that's a fact, why are we talking about it? Why isn't that said if you're going to be hearing about excited delirium? Then we turn to Dr. Baker, for example, where there's a discussion of homicide, and you were told that homicide was a medical term. That's not what Dr. Baker said. Dr. Baker said homicide means killed at the hands of another. It means at the hands of another is what homicide means. At the hands of another. And he was pretty clear in discussing the cause of death. He said it was cardiopulmonary arrest, complicating law enforcement, subdual, restraint, and neck compression. And he did explain what complicating means. He said it means in the environment of. So it reads as though it's called cardiopulmonary arrest in the environment of law enforcement subdual, restraint, and neck compression. What you were just told, and that was attributed to Dr. Baker, is that somehow he meant that this was an unexpected result. It was an unexpected result of the law enforcement subdual, restraint, and neck subdual, restraint, and neck compression. Dr. Baker didn't come in to talk to any of us about use of force by police officers. He's not in the mind of any police officer. It is not what he said. There were simply words that were put into his mouth, but you check your notes on what his testimony actually was, and you'll see that that wasn't it. You've heard now for the umpteenth time in this trial, what is the evidence on autopsy for asphyxia if you're looking at the body tissues? You've heard it from witness after witness on the stand. I even pulled out big, giant, thick textbooks that even Dr. Fowler, the defense own expert, says these are reliable authorities on it. Every one of them says that in half or better of the cases where somebody has clearly died from insufficient oxygen, you don't see any evidence in the body tissues. Ladies and gentlemen, that's a fact. Now, if this is supposed to be about performing an honest assessment, looking at the totality of the evidence, how is that not mentioned to you in summarizing the evidence? How is it not mentioned to you? And I can't even stop there, because you were also told about the law that applies to this. You first told by Judge Cahill, and no question that was accurate. But then you were told by Mr. Nelson, no question that was not accurate. I'll tell you what I mean. When he was talking about causation, and he talks about fentanyl, heart failure, hypertension, and he said that we have to show beyond a reasonable doubt that none of these other factors played a role. That's not the law. And you don't have to believe me. You'll be able to read it yourself. You'll have the instructions there and see if Mr. Blackwell isn't telling you the truth. That what we need to show is that the defendant's actions were a substantial causal factor in his death. Doesn't have to be the only causal factor. Doesn't have to be the biggest substantial factor. It just has to be one of them. A substantial factor in the cause of death. And the instruction will say that the fact that other causes contribute to the death does not relieve the defendant of criminal liability. There can be other factors. In fact, Dr. Baker had a section, I think, that was called Other Factors, and he was clear. Those other factors are not direct causes of the death. The direct cause was cardiopulmonary arrest that was in the environment of the police, subdual, restraint, and neck compression. Point blank. When I got back and got him to question him again after Mr. Nelson was finished, all I did was ask him about what he had written in his certificate on the case. Cause of death, cardiopulmonary arrest. Manner of death, homicide at the hands of another. He was crystal clear on it. He did not equivocate. But what you have gotten here is a number of what I'd call stories that once you analyze them and you once you analyze them and against the facts and the evidence that you've heard, you'll see what I mean. Take, for example, the notion that Mr. Floyd dying of cardiopulmonary arrest, dying from low oxygen, was just coincidental. He just happened to die at the same time, in the same place, of factors completely unrelated to what Mr. Chauvin was doing with his subdual, restraint, and neck compression. That's a story, ladies and gentlemen, and defies common sense. I'll show you what I mean. Oh, sorry. Yeah. So if we just treat each day that Mr. Floyd lived. He was born October 14th, 1973, and just made it a dot on a page. And we looked at over his lifetime. You'll see here, if we look over 10 years, 20, 30, 40 years, up to May 25th of 2020, that means that Mr. Floyd would have lived up to that day 17,026 days. Now, only one of these dots corresponds to May 25th. Only one of them. All the rest of these days, all the rest of these dots represent days that Mr. Floyd was living. He was breathing. He had a being. He was living. He was breathing and had a being with every single disorder that Mr. Nelson has chronicled. Each and every day, you know, with his struggles with opioid addiction, with his high blood pressure, et cetera, every single day, except the one day. May 25th, that tiny little speck of a dot, and not even that whole day. Because as we know, there was a 10-minute segment, 9 minutes and 29 seconds, that he didn't survive. So in one day's time, there are 144 of those 10-minute segments. And only one of them was the reason that Mr. Floyd failed to survive. And what happened in that space? Well, you know what happened. Ladies and gentlemen, that's where there was deadly force applied by Mr. Chauvin. We know it was deadly force because we heard from Officer Zimmerman on the stand, who told us it was deadly force. He said it's deadly force because it's force capable of killing a person, which makes it deadly force. Now, deadly force, ladies and gentlemen, once you see what Mr. Floyd was subjected to with this deadly force in the prone position, there are certain consequences or the risks that come with the prone position and the use of this kind of deadly force. And that primary risk is it affects your breathing. You heard that from witness after witness after witness. It affects your breathing, makes it harder to breathe. You put the subject into the prone recovery position as soon as possible because you don't want to affect their breathing, low oxygen. Do you have evidence of low oxygen here? There is evidence of low oxygen, ladies and gentlemen, that is medically unassailable, medically. Take, for example, the fact that Mr. Floyd had an anoxic seizure. That is, he's already unconscious, not breathing, and the body is simply having a twitching reflex. That anoxic seizure represents low oxygen to the brain. And that is what causes the anoxic seizure. But not only that, he suffered from, remember, PEA. And you remember we talked about the PEA, the pulseless electrical activity, PEA? The common cause of PEA is low oxygen. You can't fake it. You can't make that up. There's evidence of the low oxygen, and it would have been what would have proceeded from the use of this very kind of deadly force. And this deadly force took place, as we know, within the 9 minutes and 29 seconds. Now, you heard the statement that the state is seeking to ignore significant medical issues, and nothing could be further from the truth. What you heard from doctor after doctor, whether it's Dr. Langenfeld, the ER physician, Dr. Rich, the cardiologist, Dr. Tobin, that you've heard so much about, Dr. Smock, so many of the doctors you heard, that here's, and Dr. Baker also, and Dr. Thomas, here's where they all converge, is that they recognize, first and foremost, that there was a use of force by Mr. Chauvin that set off a number of things medically for Mr. Floyd that culminated in his death. Remember, he died of cardiopulmonary arrest. That means the heart has stopped and he's no longer breathing. Now, Dr. Baker will tell you that this stress to which Mr. Floyd was subjected in the subdual and the restraint by Mr. Chauvin and others was enough in, of, and by itself to explain Mr. Floyd's demise. When asked the question, what about his oxygen levels? Did he have insufficient oxygen? That's not something I can calculate as a forensic pathologist, said Dr. Baker. That's not something I can calculate as a forensic pathologist, said Dr. Fowler. And Dr. Thomas said the same thing. But the doctor, they said they would defer to pulmonologists in every case, which is who and what we have in Dr. Tobin, who did the calculations, who could tell you how much oxygen was in Mr. Floyd's body. And not only that, he could tell you that when he's put into the prone position, that his oxygen would have decreased by 24%. He can tell you that when weight was put on Mr. Floyd's back, the oxygen diminished to 43%. He can tell you that with the weight on his back, that the hypopharynx would have narrowed to 15% or lower, making it difficult for anyone to breathe through. He was able to tell you medically, scientifically, not only could Mr. Floyd not have survived this diminution in oxygen reserves and supply, but no human being could have survived, based on the science. Based on the science. Now, if it's dismissed as theoretical, which is a word I think I heard, theoretical, well, it's the same theoretical that Dr. Fowler said that he would defer to someone else to create because he can't do it. And that's exactly what Dr. Tobin did. And so here, ladies and gentlemen, we're only required to show you that Mr. Chauvin's conduct was a substantial cause, a substantial factor in Mr. Floyd's death. Did he simply die automatically from and exclusively from the low oxygen? Ultimately, the low oxygen translates into not breathing and the heart stopping because we have cardiopulmonary arrest. Did it first impact the heart, then the heart stopped first? Ultimately, they both stop because we have cardiopulmonary arrest, all stemming back to the subdual, restraint, and neck compression from Mr. Chauvin. They all agree that that was the precipitating point. And then from there, the stresses, the strains on Mr. Floyd's body, the low oxygen, culminated in his ultimate demise and his passing away. So I want to address kind of several other points on the heading of what I think are stories that you've heard versus I think the truths here. You know, when the case started, I think you all were asked and talked to about there being two sides to every story, two sides to every story, which is one of the most dangerous things, I think, about the process of truth, because it suggests that everything is simply reduced to a story. And if it is a story, that means there can be multiple sides to a story, and there can never be a truth or reality, except that what we're about here is getting to the truth and not simply stories. Now, it is most certainly right, for example, for a police officer to take seriously this overarching mission of the police department, embracing the sanctity of life and protection of the public as the highest values. But it is equally wrong. It is equally wrong to take this badge, which is a symbol of a commitment to a higher calling to serve the people, to use this badge as a license to abuse the public, to mistreat the public, to not follow proper procedures, to not render aid when you should administer aid. That's wrong. That's not a story. That's simply wrong. And the only two sides to that would be the W and the G for that being wrong. Now, you have heard statements to the effect of Mr. Chauvin being concerned about the bystanders and about others. Well, if you are looking at the totality of the evidence, you have to bear in mind that at all relevant times here, there were 5 grown men police officers right there, and 4 right there on the scene. And then you got Officer Chang, who was there too. There's a radio to call for backup if they felt it was needed. You didn't hear any evidence about any call for backup at all. Now, there was concern here that Mr. Chauvin was concerned. And I won't say much more about body language than has already been discussed. And you'll decide for yourself whether that was the face of one who was afraid at the time, because he had all of the power at this point. He had the bullets, guns, he had the mace that he threatened the bystanders with. He had backup, he had the badge, and he had all of it. And what was there to be afraid of here, particularly at this scene? There were 3 high school juniors there and a second grader who was going to the store to get candy. There was a high school senior who was taking her cousin to the store, a first responder on the scene. And there was Donald Williams, who wanted nothing more than to try to intervene to try to save Mr. Floyd's life. Mr. Charles McMillan, a 61-year-old man, that if I gave him a name, I would call him the mayor of the neighborhood. He just likes to see what's going on and to look out for things, but he was simply there to try to also to intervene to try to save Mr. Floyd's life. So this wasn't the face of fear or concern or worry. You've seen what the face of fear and worry looked like that day at that time. That's what fear and worry looked like. When Mr. George Floyd was well aware that with one wrong move of his hand, one turn in the wrong direction, and it could be his last turn, that he could be shot to death over an investigation around a fake $20 bill. That's fear. Now, you're told some stories about the bystanders and the suggestion that they were an unruly crowd. You've gotten to meet them now. You've gotten to meet 2/3 of ones who were there at that time. I described them earlier as a bouquet of humanity. And I call them that because they came in different ages, different genders, different races, and they all came together focused on the one thing, which was they saw that a human being they did not know was suffering, and they wanted to try to intervene to stop the suffering. And in that sense, they were not only symbols of the love and caring we want to encourage, but they were also something more than that. They were also symbols of what it means to respect this badge, because they were in a very difficult spot then. You saw them on the stand almost to the last one in tears. You felt the anguish even a year after the fact. They felt torn between their love for the sanctity of life itself that had them wanting to intervene to try to save Mr. Floyd's life, and on the other hand, their respect for the authority that the badge represents, for the city, for the state. They were torn between it. Now, the ultimate proof of this is if those bystanders did not respect this badge, they could very easily have taken the law into their own hands and simply have removed Mr. Chauvin. Then we wouldn't have to have any discussions about how reasonable it was for him to stay on a man's neck who wasn't even breathing. We wouldn't have to have any of these kinds of discussions at all. But none of them did that. None of them did that because they respected this badge, even if it tore them up inside. None of them did that. Instead, they called the police on the police. Instead, they picked up their phones to memorialize what they were seeing so that it could not be forgotten and so that it could not be misrepresented. Instead, they waited for their day to come in and talk with you. Not, ladies and gentlemen, to tell their story, but to tell the truth about what they experienced. They didn't deserve to be called unruly because they weren't. And you will hear time and again, oh, the crowd was getting louder. Oh, the crowd was getting more agitated. Earlier in the trial, you hear, oh, they were getting angrier and angrier. And so we can't see somehow what it is they're getting upset around. The fact that a defenseless, helpless man is literally losing his life one breath at a time right in front of them, and there's nothing that they can do. If you love life, you get excited when you see life being taken, when that's your perception. That's what they were excited about. And if they all just simply wanted a donut in watching this, you might wonder what's wrong with them. That's why they were upset. So you felt their pain, you felt their sense of helplessness. What you heard about him was a story, ladies and gentlemen. The stories really are just excuses that get told.
Disregard the use of the word stories.
The fact of the matter is, ladies and gentlemen, that there can be no excuse for police abuse. And I'll be clear, ladies and gentlemen. I will tell you if I think there's a fact that's been altered. I will tell you what it is, and that's all I ever mean when I say story. But there's no excuse, ladies and gentlemen, for police abuse, and you've heard any number of these. So let me walk through some of them. You've heard accounts that the traffic was distracting to Mr. Chauvin. Well, the fact was that you heard from the 911 dispatcher, Jenna Scurry, who was watching the scene. And she said that the officers remained in the same place, in the same positions for so long on top of the body of Mr. Floyd that she thought the camera was broken and frozen. They weren't distracted. They weren't looking around because they were concerned about being disturbed by the traffic or anything else. They had an officer there, Officer Tao, whose job it was just to fend off and keep away distractions, and could have called others if needed. You've also heard about the paramedics took too long. The paramedics took longer to get there than was planned. Should have been there within 3 minutes. And your common sense will tell you that the mere fact that the paramedics took longer than Mr. Chauvin may have thought is certainly not a reason to either use excessive force or to abuse or to be indifferent to the fact that somebody is no longer breathing and doesn't have a pulse, that the paramedics took too long. You heard about the paraganglioma, which was also referred to as an incidentaloma, because that's how rare it is and insignificant it is. The hallmark of a paraganglioma, headaches. Mr. Floyd wasn't reporting headaches. So if you're going to talk about a paraganglioma, why don't you talk about the fact that you know the hallmark is headaches and he didn't have them? If this is about getting at the truth and as well performing an honest assessment, if that's what we're doing. The fact of the matter is, the paragangliomas, there have been 6 cases in reported history, all of reported history, where somebody had a sudden death from a paraganglioma, ever, period. Carbon monoxide. Now, other than Mr. Nelson saying that the car was turned on at the time, nobody from that witness stand from the evidence in this case said the police car was on. You did hear it was a hybrid vehicle. You know, how are we talking about carbon monoxide with a car that there's no evidence from the stand that the car was even on? If we're going to talk about carbon monoxide and give this a reasonable, honest assessment. But even more to the point about carbon monoxide that you just can't lose sight of. Whose car was it, ladies and gentlemen, that if Mr. Floyd is being subdued on the ground by Mr. Chauvin, and if he puts his face in front of a tailpipe of a car that's spewing out carbon monoxide, why isn't that an unreasonable use of force by an officer? In your custody is in your care. It's not in your custody, I don't care. In your custody is in your care. What reasonable police officer would apprehend someone on the ground, subdue them, and put their face in front of a tailpipe of a car and then think that's a defense? Here, not particularly fair. There's no evidence the car was ever even on. And you learned all you need to know, which was if he was suffering from carbon monoxide, as Dr. Tobin told you, you wouldn't be able to get a 98% oxygen saturation from the oxygen they gave him artificially. You heard about the fentanyl overdose. And with this one, you were just told, oh, earlier that afternoon, he was asleep in the car. Ladies and gentlemen, that's not the hallmark of somebody who dies from a fentanyl overdose. It isn't just that you took a nap and dozed off. If you pass away from a fentanyl overdose, you cannot be awakened. You are in a coma. If people are shaking you, it is to no avail. If we're doing an honest assessment of the facts, looking at the totality of the circumstances, if we're going to talk about fentanyl, death by fentanyl or an overdose, why isn't that said? He does not fit the description of anyone who dies from a fentanyl overdose, and even Dr. Fowler conceded it from the stand in terms of what a fentanyl overdose looks like. It does not look like somebody who's saying, I can't breathe, my neck hurts, my back hurts, everything hurts. You know, you can't win. I'm not trying to win. That's not what happens when somebody is suffering or dying from a fentanyl overdose. They are completely non-responsive and not reactive at all. Methamphetamine, ladies and gentlemen, what meth? There was so little of it that it was below the therapeutic levels that are given. You heard that from the toxicologist, from NMS, the laboratory that Hennepin County sends off, the medical examiner pathology, not pathology, but blood samples to test for tox. He told you it was a minuscule amount of meth that was in his blood. And then we heard about the pills. Now, on cross-examination on the pills, I brought out the fact that what they were saying was a pill that he was taking in the car was just as likely chewing gum, and showed you just before he was in the car, he was chewing gum in the store, opened his mouth, you saw the same like substance in his mouth. But here's the deal about the pills. If we're really going to give this an honest assessment of the evidence, why are we talking about pills that are not in his system? We know what's in his bloodstream already. We know he struggles with the opioid addiction. Why are we talking about pills that we know were not in George Floyd? Why? You have to decide that for yourselves, ladies and gentlemen. Why is that even being brought up when we know what's in his bloodstream? What is the point? And you keep hearing drugs in the car, drugs in the car. And the drugs were one pill. One pill. It was not in George Floyd. And then the suggestion that he was somehow taking it in handcuffs in the police car, which makes no sense. There was no evidence of George Floyd taking any pills in the police car at all. There was a pill found there only. You heard references in talking about Dr. Chauvin and his 46 years of experience studying the way people breathe. But, you know, Mr. Chauvin's not a medical doctor. He doesn't have these years of experience and hours to pour over records. He didn't need it, ladies and gentlemen, because you know who else is not a medical doctor? 9-year-old girl is also not a medical doctor. You didn't need to be a medical doctor to understand that when somebody's saying, I can't breathe, and not just saying it, everything about them is showing that they can't breathe. And when that ends, they just are passed out. You don't need a PhD. You don't need an MD to understand how fundamental breathing is to life. And when somebody's saying, I cannot breathe, and they have passed out, and you're aware that they don't even have a pulse, even a 9-year-old little girl knows it. Get off of them. That's all you needed to know in that case. You just a couple more of these because I can't even do them all because there were so many. This concern that George Floyd would somehow come to again. He would come back around again. And they'll say, not we didn't really mean superhuman strength, except maybe we really did mean superhuman strength because he's going to have all this extra strength now and he's going to do dastardly things. Now, we heard from 3 medical examiners, ladies and gentlemen, 3 of them. Between the 3 of them, they probably have done close to 15,000 autopsies. And not a single one of them testified about one instance ever where somebody who didn't even have a pulse somehow spontaneously came back to life, broke handcuffs, and rampaged the city. It's the facts of this case, not some other thing. Mr. Floyd didn't even have a pulse. That didn't justify keeping your knee on his neck when you should have been administering CPR when you could have brought him back to life again because you're afraid that he would come to with no pulse and rampage the city. That's the sort of thing you see in Halloween movies, ladies and gentlemen, not in real life. Not in real life. The idea that Mr. Floyd suffered from a sudden death, which is what Dr. Fowler was saying. Now he'll say that Mr. Floyd had a fatal arrhythmia in the end. That's misleading in a way because, as you've heard from doctor after doctor, ultimately everybody dies in the end of a fatal arrhythmia. Everybody dies of cardiopulmonary arrest, the heart stops and the lung stops. And then the last thing that happens is, bloop, you get an arrhythmia, and then that's it. Now, is there any evidence that there was an arrhythmia as the primary cause of his death, unrelated to the subdual, restraint, and neck compression on the ground? Zero. There was zero evidence that he had a heart attack. Zero. In fact, his heart was in such normal condition that Dr. Baker, during the autopsy, didn't even have a need to photograph it intact because it was so normal. Now, Dr. Rich did not say anything akin to George Floyd having a normal heart. That's not what he said. What he said was that he had a strong heart. He had a strong heart. And what he meant by that is that he sees patients all the time who may be in need of transplants, who have serious cardiac disease, and they can't even get a normal blood pressure. And he talked to you about how George Floyd, having lived with this for some time, explains how it is that his body and its the arteries that serve the heart were able to compensate in the case of Mr. Floyd, and such that he did not die of a fatal arrhythmia, and there's no evidence that he died of any kind of a heart abnormality. Just two more of these things I just want to clarify. There was a lot of discussion about the police conduct. The situations can change rapidly from moment to moment. And on this, I don't want you at all to lose sight of, again, the facts here. That for the 9 minutes and 29 seconds, the problem was there was nothing moving or changing, no matter what. Whether Mr. Floyd was calling out for his life, whether he was motionless with an anoxic seizure, whether he had no pulse. There was no movement, no split-second decisions, no moment to moment. To the extent you're hearing that as representative of this case, it is not representative of this case, does not meet the facts of this case at all. So the fact of the matter is, ladies and gentlemen, the use of unreasonable force, the unreasonable use of force is an assault. Here was an assault, and it contributed to the death of Mr. Floyd. Now, you were told with respect to the law that the state needs to show that Mr. Chauvin intended to act unlawfully or to break the law. Look at your instructions. That's not accurate. We will, in fact, and we own our burden of showing that he, in fact, acted unlawfully, but not having to prove that he intended to act unlawfully. We need only to show that he intended to do what he did, which was to put the knee on the neck, the knee on the back, and against the shoulder, that it wasn't an accident, and that we will show. And we own that burden. So there really aren't two sides to the story about whether this use of force was unreasonable. It was not authorized by the Minneapolis Police Department. The pressure on Mr. Floyd's neck did affect his ability to breathe. And I know that you were told when Mr. Nelson was just here that this was not a choke. It was not a chokehold, and that Donald Williams had suggested or so testified. And if you remember that testimony, Donald Williams disagreed with him every time and said that was in fact a chokehold, even on the one side, and he explained how that even works. And while Mr. Nelson quibbled with him, Donald Williams never gave that up in his testimony. So there aren't two sides to the story as to the unreasonable use of force. And when Mr. Floyd is saying, please, please, I can't breathe, 27 times in just a few minutes, you saw it when Mr. Chauvin did not let up and we didn't get up. Even when he passed out, not breathing anymore, he doesn't let up or get up. When he knows he doesn't have a pulse, he doesn't let up or get up. Even when the ambulance comes, he doesn't let up or get up. Even then, they have to come up and tap him before he will let up and get up off the body of Mr. George Floyd. And they try to resuscitate him in the ambulance, and they never do. He never regains consciousness. He never breathes again. His heart never pumps again. And Mr. George Floyd was deceased. So finally, ladies and gentlemen, I will sit down in a minute, but I wanted to save till the end what I thought was the biggest shading of the truth, or what I call story.
Object to that, Your Honor, and
You'll disregard the phrase shading the truth.
Well, here's what I thought then was the largest departure from here, the evidence. I'll show it to you. You were told, for example, that Mr. Floyd died because his heart was too big. You heard that testimony. And now, having seen all the evidence, having heard all the evidence, you know the truth. And the truth of the matter is that the reason George Floyd is dead is because Mr. Chauvin's heart was too small.
The jury, could grab your instructions again. And turn to page 11. Members of the jury, if you have any question about any part of the testimony or any legal question after you have retired for your deliberation, please address it to me in writing and give it to the sheriff's deputy with the juror number of your foreperson on the note. It will take some time to answer any questions because I will have to consult with the lawyers and receive their input before answering your question. I do not say this to discourage questions, but only to advise you that it will take some time to provide you with an answer. As I told you, you will take with you into the jury room copies of the instructions that I am reading to you. The lawyers and I have determined that these instructions contain all the laws that are necessary for you to know in order to decide the case. I cannot give you a trial transcript. No such transcript exists. We count on the jury to rely on its collective memory. You have been allowed to take notes during the trial, and you may take those notes with you into the jury room. You should not consider those notes binding or conclusive, whether they are your notes or those of another juror. The notes should be used as an aid to your memory and not as a substitute for it. It is your recollection of the evidence that should control. You should disregard anything contrary to your recollection that may appear from your own notes or those of another juror. You should not give any greater weight to a particular piece of evidence solely because it is referred to in a note taken by a juror. Now, we all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of, and others we might not be fully aware of, which is why they are called implicit or unconscious biases. No matter how unbiased we think we are, our brains are hardwired to make unconscious decisions. We look at others and filter what they say through the lens of our own personal experience and background. Because we all do this, we often see life and evaluate evidence in a way that tends to favor people who are like ourselves or who have had life experiences like our own. We can also have biases about people like ourselves. One common example is the automatic association of male with career and female with family. Bias can affect our thoughts, how we remember what we see and hear, whom we believe or disbelieve, and how we make important decisions. As jurors, you are being asked to make an important decision in this case. You must, 1, take the time you need to reflect carefully and thoughtfully about the evidence. 2, think about why you are making the decision you are making and examine it for bias. Reconsider your first impressions of the people and the evidence in this case. If the people involved in this case were from different backgrounds, for example, richer or poorer, more or less educated, older or younger, or of a different gender, gender identity, race, religion, or sexual orientation, would you still view them and the evidence the same way? 3. Listen to one another. You must carefully evaluate the evidence and resist and help each other resist any urge to reach a verdict influenced by bias for or against any party or witness. Each of you have different backgrounds and will be viewing this case in light of your own insights, assumptions, and biases. Listening to different perspectives may help you to better identify the possible effects these hidden biases may have on decision making. And 4, resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or unconscious biases. The law demands that you make a fair decision based solely on the evidence, your individual evaluations of that evidence, your reason and common sense, and these instructions. When you return to the jury room to discuss this case, you must select a jury member to be foreperson. That person will lead your deliberations. In order for you to return a verdict, whether guilty or not guilty, each juror must agree with that verdict. Your verdict must be unanimous. You should discuss this case with one another and deliberate with a view towards reaching agreement if you can do so without violating your individual judgment. You should decide the case for yourself, but only after you have discussed the case with your fellow jurors and have carefully considered their views. You should not hesitate to re-examine your views and change your opinion if you become convinced they are erroneous. But you should not surrender your honest opinion simply because other jurors disagree or merely to reach a verdict. Now, a single verdict form for each count has been prepared for your use, and when you have finished your deliberations and have reached a verdict as to a specific count, the foreperson should mark the appropriate choice on the form with an X, and then date and sign the verdict form, filling in the foreperson's juror number on the indicated line, and then signing the foreperson's name on the second line. And just so you know, the forms look like this. So there's very little to add, just an X, your juror number of the foreperson, and the foreperson's signature. The order in which the guilty and not guilty choices appear on the verdict forms is strictly alphabetical and should not in any way be considered as indicating which choice is the correct choice. When all the verdict forms are completed, the forms should be placed in the provided envelope, sealed and given to the deputy, who will convey the verdicts to the court. At a time designated by the court, your verdict will be read out loud in the courtroom in your presence. During your deliberations, you must not let bias, prejudice, passion, sympathy, or public opinion influence your decision. You must not consider any consequences or penalties that might follow from your verdict. You must not be biased in favor of or against any party or witness because of his or her disability, gender, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Your verdict must be based solely on the evidence presented and the law that I give you. Your like or dislike of any witness, attorney, or party should not have an effect on the outcome of the case. The state of Minnesota and the defendant have a right to demand, and they do demand, that you will consider and weigh the evidence, apply the law, and reach a just verdict, regardless of what the consequences might be. You must be absolutely fair. Remember that it is fair to find the defendant guilty if the evidence and the law require it. On the other hand, it is fair to find the defendant not guilty if you are not convinced of his guilt beyond a reasonable doubt. Now, members of the jury, the case is in your hands as judges of the facts. I am certain that you realize that this case is important and serious and therefore deserves your careful consideration. Deputy? Do you swear that you will keep these jurors together, separate from all other persons, and that you will not allow anyone to communicate with them or overhear their deliberations, that you will not make any comment to them about the law or the facts in this case, and that you will not disclose to anyone except this court anything which you may learn from their deliberations?
I do.
Thank you. Members of the jury, you're going to go with the deputy now back to your usual room, including jurors 96 and 118. You, however, will be diverted to my office. You are our alternates and will not be a part of the deliberations, but I would like to talk to you a little bit. So you can go with the remainder of the jury, but follow the sheriff deputy instructions. All rise for the jury. Be seated. We're still on the record. All right, a couple of things. I know the defense was in the process, I think, of making expressing a concern or an objection to counsel's argument belittling the defense. Is that what I correctly perceived that objection? I think we dealt with it sufficiently during the objections during the rebuttal. So there'll be no additional instruction in that regard.
I do believe that it constitutes prosecutorial misconduct and is potentially basis for grounds for a mistrial.
Okay, I think the use of the word nonsense is what you're talking about originally.
Originally, Your Honor, but then in rebuttal, there were repeated comments about how we were, and implications that we were shading was one example, that we were creating Halloween stories was another example, that these were stories, and that was a repeated comment. Stated that we misrepresented facts and put words into Dr. Baker's mouth, that we made several statements that they put forth as stories. After the court instructed him to stop using the word stories, he clarified that it's just fabricated facts. And so there were multiple references to that, that we were shading the truth, right? I mean, and again, so multiple objections. This is essentially governed by State versus McDaniel. And the final argument to the jury, a prosecutor is governed by a unique set of rules which differ significantly from those governing counsel in civil suits, and even those governing defense counsel in the very same criminal trial. These special rules follow directly from the prosecutor's inherently unique role in the criminal justice system, which mandates that the prosecutor not act as a zealous advocate for criminal punishment, but as the representative of the people in an effort to seek justice. For example, that when a prosecutor argues that a defense is meritless, she cannot belittle the defense either in the abstract or suggesting that the defense was raised because it was the only defense that succeeded. So there's lots of law in this, Your Honor, and essentially these comments, the repeated comments, constitute prosecutorial misconduct.
I'll note for the record that I overruled the first objection when Mr. Blackwell used the word story because it was isolated and in its context, it did not seem to me to be belittling. However, the continued use of it, I did sustain the ultimate objection that counsel made to the use of the word stories and instructed the jury to disregard it. Also on shading the truth, that I sustained the objection and instructed the jury to disregard it. I'm not making any findings as to whether it was the type of prosecutorial misconduct that would result in a mistrial. I think it was adequately addressed by the court's instruction to disregard. All right. With regard to other matters we have, I think there were some bench conferences that that are fairly historical that you wanted to memorialize, but also a new motion based on events this weekend. Mr. Nelson.
Correct, Your Honor. Your Honor, as the court is aware, and as prior to coming into court this morning for closing arguments, we had an in-chambers discussion about events of this weekend, specifically referencing that an elected official, United States congressperson, was making what I interpreted to be, and what I think are reasonably interpreted to be, threats against the sanctity of the jury process, threatening and intimidating the jury, demanding that if there's not a guilty verdict, that there would be further problems, Your Honor. And given the fact that this jury has not been sequestered, it has been my position all along throughout the course of this case that this jury should have been sequestered at the outset. The jury has not been continually has not been continually told to stay away from media, only media about this case. There is a high probability that members of this jury have seen these comments, are familiar with these comments, and things that have happened throughout the course of this trial. I mean, it's unfortunate that there was another situation that occurred during the course of this trial. But obviously, Your Honor, we also, as I mentioned previously too, one of the jurors does live in the city, Brooklyn Center, as I recall.
Although I think that is the alternate we just dismissed.
I do not believe so.
I thought it was, but go ahead.
Now I'd have to go back and double check my notes. So, Your Honor, I mean, I just think that the sum total of this trial happening in such a public context, number one. Number two, while all of this, I mean, the media attention is profound. I have admittedly stayed away from 99% of it, but that has required me to stay away from all media. I mean, this case has found its way into even fictional television. Your Honor, there were I was advised of 2 television shows in the course of the past few days that specifically involve references to this particular case and the reactions of the characters in these stories to this particular case. This jury has, despite all best efforts, has been bombarded with information relevant to this case. It is impossible to stay away from it unless you literally shut off your phone or you shut off your TV, you shut off your computer. And no such instructions have been given during the course of this trial.
Well, to be fair, the last few times I've advised them, I told them don't watch the news. Pure and simple.
Right, but if you can't even watch your favorite Thursday night television program and it comes up, I mean, this is the problem, right? And why I have felt that this jury should have been sequestered from the very beginning.
Understood.
To make that clear. And so I had moved based on this again for a mistrial. The idea is that it is a public trial. I think the court has accomplished that, but the media attention is so profound. It is such a, I mean, it is such a modern comparison. I mean, it's such a modern problem to have where literally I walked from this courtroom into the courtroom where I've been permitted to stay. During the course of this trial, I've received literally thousands and thousands and thousands of emails. So much so that I don't even look at that particular email anymore. So, I mean, but my phone gives me alerts on things that just happened. I mean, you can't avoid it. And it is so pervasive that I just don't know how this jury, it can really be said to be that they are free from the taint of this. And now that we have U.S. representatives threatening acts of violence in relation to this specific case, it's mind-boggling to me, Judge.
Well, I'll give you that Congresswoman Waters may have given you something on appeal that may result in this whole trial being overturned. But what's the state's position?
The state's position, first and foremost, and this is a concern I raised at the beginning of the proceedings, well into jury selection, is that we can't allow statements like this, vague statements, to be considered a part of the record on appeal. If there's a specific statement that a specific U.S. representative made, then there needs to be some sort of formal offer of proof with the exact quotes of the exact statement or some kind of a declaration. And I'm sure Mr. Nelson can do that if he thinks that that's something that's appropriate. I don't know that this particular representative made a specified threat of violence. I don't know what the context of the statement is. I also don't know what television shows Mr. Nelson is referring to in terms of any of this. And so I just don't think that we can muddy the record with vague allegations as to things that have happened without very specific evidence that's being offered before the court. As a practical matter, through the jury selection process, the court has provided instructions, has determined whether or not there are any outside influences. The law presumes that the jury follows the judge's instructions, and the court has instructed the jury today that they're not to let any outside influences or public opinion sway their deliberation. And the law presumes that they would be capable of doing that. And so without any sort of specific offer of proof or information in the record, without any specific evidence that this particular jury was influenced in any particular way, I believe that the defendant's motion should be denied.
Your Honor, I make my comments, in the context of this is all such an evolving situation. Obviously, I spend my weekend preparing for closing remarks. And I certainly can supplement the record with news articles. I can supplement the record with the storylines of the particular shows that were brought to my attention. So I'm making it to note the record at this particular point, and I can certainly supplement.
Yeah, you can supplement the record with whatever media reports. I'm aware of the media reports. I'm aware that Congresswoman Waters was talking specifically about this trial and about the unacceptability of anything less than a murder conviction, and talk about being confrontational. But you can submit the press articles about that. This goes back to what I've been saying from the beginning. I wish elected officials would stop talking about this case, especially in a manner that is disrespectful to the rule of law and to the judicial branch and our function. I think if they want to give their opinions, they should do so in a respectful and in a manner that is consistent with their oath to the Constitution, to respect a co-equal branch of government. Their failure to do so, I think, is abhorrent, but I don't think it has prejudiced us with additional material that would prejudice this jury. They have been told not to watch the news. I trust they are following those instructions, and that there is not in any way a prejudice to the defendant beyond the articles that we're talking specifically about the facts of this case. A congresswoman's opinion really doesn't matter a whole lot. Anyway, so motion for mistrial is denied. With regard to, there was a report that counsel were made aware of a few days ago that a juror may have been talking to a major media outlet. We checked with that major, and it appeared right from the beginning that it was third-hand hearsay telephone game. That media outlet, in fact, took it very seriously, did a nationwide contact of all of its reporters and staff to check out any veracity, and there apparently is none whatsoever. Nobody from this major media outlet made any contact, and I find that credible. And so just for the record, I pass that along. Now, I think we still have the memorialization, but we also have to talk about a Blakely waiver.
Yes, Your Honor. So a couple of things. In terms of the memorialization of the sidebars and the objections, we had previously provided, and we had suggested that we provided our memorandum of the objections that the defense had made at sidebars. I am going to propose, rather than just simply reading through and taking an hour's time, that we submit those objections in writing now that
Right.
happened, and in consultation with the state, and they can include their objections that we did not include.
It'd be nice to include just essentially a stipulated pleading that sets out what the objection was and what the court's ruling. There's no need to repeat what the arguments were. The only thing that you need to preserve for appeal is what the objection was and what the court's ruling was. So I would encourage both parties to get together and figure that out and file it reasonably quickly. I mean, it doesn't have to be today, tomorrow, or even the next day, but just to get on it while our memories are fresh.
And if there's a discrepancy between the memories, Your Honor, I'm expecting that we're going to be able to come up with a stipulated document. But if there's anything that needs to be set out, we can just indicate our contrary memories of that, and it should be pretty simple.
Absolutely. I think that would be the best way to memorialize this in any case. All right. Other than Blakely, do we have any other issues to make a record of?
No, Your Honor. I think we just need to have some administrative discussions about questions, timing.
And we can do that in a chambers discussion. All right. With regard to Blakely.
Sure. I have not yet had Mr. Chauvin execute the written waiver. Again, I do have it. We can print it and get that taken care of. But I can do an oral waiver now with the court.
If you would.
So, Mr. Chauvin, you can take your mask off. Mr. Chauvin, you're aware that during the course of these proceedings, the state has filed what's called the Blakely notice, or a notice to seek an aggravated sentence, correct?
Yes.
I have explained to you the bases on which the state is seeking to have an aggravated sentence imposed in the event of a conviction on any one of the counts here, correct?
Correct.
We've discussed those, and I have specifically advised you that you have a right to have a jury decide whether or not the state has proven those grounds for an aggravated sentence beyond a reasonable doubt. You have a right to have a jury decide if you violated, right?
Correct.
And I've advised you that the state has to prove those grounds beyond a reasonable doubt.
Correct.
And we can waive that right and allow, if you're convicted, we can waive your right to a trial and allow the judge to make those determinations. I've advised you about that, right?
Yes, sir.
Now, do you want a jury to make a decision about the proof required for the aggravated factors if there's a conviction, or are you willing to waive your right to a trial on those matters and allow Judge Cahill to make those decisions?
I'm willing to waive it and have Judge Cahill decide on those issues.
Mr. Chauvin, again, I'm going to address you individually because this is another one of the decisions you have to make for yourself. This is a waiver of your jury trial right when it comes to aggravating factors. Normally, we would submit a verdict form with interrogatories with a question and yes or no options. And that's what generally the jury would consider. In order to say yes, the jury would have to be convinced beyond a reasonable doubt. The burden of proof does not change. It's only that I'm going to be the one who's answering those yes and no questions. It was always true that based on whatever the answers are to those, that I would be the one deciding if they constitute legally substantial and compelling circumstances, and we would expect briefs from both sides on that. Do you understand that?
Yes, sir.
So basically, I will be answering those verdict form questions instead of the jury, applying the standard of proof beyond a reasonable doubt. Is that what you want to have happen?
Yes, sir.
All right. I would ask that you file a written Blakely waiver in addition.
We will, Your Honor.
All right.
I just have a question on the form that was provided, and we can, again, it's an administrative question.
Right. It's an administrative memorialization, so you can do that off the record. All right, counsel, I'm going to talk with basically give instructions to the alternates. Give me 20 minutes, and then why don't you come on back? All right. Otherwise, we are in recess until we hear from the jury.